Hello everyone, I am Anuj Nakade and welcome to LiveLaw. The Kerala High Court has made a major ruling in administrative law for the appointment of teaching staff at universities. Dr. Joseph Skaria, an assistant professor of Malayalam, challenged the inclusion of one Priya Varghese in a provisional rank list for selection to the post of associate professor at the Department of Malayalam at Kannur University in the Kerala High Court through a writ petition. He had ranked second after Priya Varghese in this list. Priya Varghese is the wife of K.K. Ragesh, the private secretary of Chief Minister Pinarayi Vijayan. It was his case that she did not have the minimum experience of 8 years in a teaching or research position equivalent to that of an assistant professor in a university, college, or accredited research institution or industry required to qualify to be considered for the position. In November of 2022, a single-judge bench of the Kerala High Court had held that Priya Varghese did not possess the requisite teaching experience to be appointed as associate professor and directed the competent authority of the university to reconsider her credentials and decide whether she should continue on the rank list. The single-judge bench held that the experience gained by Mrs. Varghese while on deputation under the Faculty Development Program at Kannur University and Director of Student Services at Kannur University could not be treated as teaching or research experience under the UGC regulations of 2018. Then, Priya Varghese filed an appeal against this order before a division bench of the Kerala High Court. A two-judge bench of Justice A.K. Jayasankaran Nambiar and Justice Muhammad Niaz C.P. heard the matter. It was argued before this bench that the writ petition was bad for the non-joinder of necessary parties, meaning all necessary parties were not a part of the proceedings before the court. It was argued that rank list was published by Kannur University, which was not a party to the petition. The single judge had issued directions to the university for compliance without making it a party. The counsel for Dr. Joseph Skaria argued that the registrar of the university was made a party to the petition, and as per section 14 of the Kannur University Act 1996, suits by or against the university are to be instituted by or against the registrar. However, the court held that the writ petition was bad for the non-joinder of parties observing, and I quote, the provisions of Section 3 of the same Act that declares the university to be an independent body with perpetual succession and a common seal that can sue and can be sued in its own name. The statutory provisions leave us with no manner of doubt that what is envisaged therein is that any suit or like proceedings initiate against the university be done in the name of the university represented by its registrar. Beyond the question of non-joinder of necessary parties, the main question before the court was the same as the single bench: whether Priya Varghese has the necessary experience for the post. And to answer that question, the following three questions arose after. The first, can the research period undergone by the appellant under Faculty Development Program of the Kannur University count towards the research experience? Second, can the period spent by the appellant while on deputation as Director of Student Services of the Kannur University be counted as the teaching experience? And third, can the period spent by the appellant as lecturer at the Teacher Education Center at Kannur University on ad hoc or contract basis be counted towards the teaching experience? On the first question, the court held that the PhD period of candidates who are not faculty members will be excluded from teaching experience. However, if the research degree is pursued by regular faculty members simultaneous with the teaching assignment, the period will be counted as teaching experience. The court said, and I quote, the prohibition against the inclusion of the time taken for acquiring a PhD degree in computation of teaching or research experience is one that applies to candidates, by which term is intended a person who is not working as a teacher in any institution at the time of applying for the teaching post in question. Faculty members, on the other hand, refers to persons who are already working as teachers in an institution at the time of applying for the teaching post in question, and for them, the period spent on pursuing a research degree simultaneously with teaching assignment and without taking any kind of leave will count towards teaching experience. On the second question, the division bench held that the period spent by Varghese on deputation as Director of Student Services or the National Service Scheme was to be counted as teaching experience by the university as well. Finally, the court examined whether Varghese possessed the necessary qualifications stipulated for an assistant professor under the UGC Regulations 2018 at the time when she rendered her service as a lecturer at the Teacher Education Center, Kannur University, on a contract or ad hoc basis. The court found that her first spell of 8 months in service was prior to her attaining NET qualification, and hence those 8 months could not be counted as experience for the post. But the second part of her employment as a professor on contract basis can be considered valid as a teaching experience. In this order, the court also reminded the press to respect the privacy of the litigant and to follow responsible journalistic conduct. The court has heavily criticized the media for the distractions caused and warned the press to not obstruct the course of justice. The court said, and I quote, "Frighteningly frequent are those occasions when the impugned decision in the academic matter attracts media attention for some reason or the other, and the court has then to deal with the added distraction brought about the incessant newspaper and channel discussions and overwhelming social media posts. It is for this reason that courts have time and again exhorted the print and electronic media to exercise restraint by deferring discussions on matters pending before the court so that the rule of law can be better served by avoiding obstruction of the course of justice." While noting that the media must exercise caution while reporting court proceedings as not everything said by a judge during a hearing reflects the judge's views on the case, the court said, and I quote, "On its part, the media cannot be unmindful of the harm that is caused to a litigant's dignity and reputation through unjustified comments and remarks, often based on oral remarks made by a judge during the adjudication proceedings, notwithstanding that the litigant ultimately succeeds in those proceedings. They must note that no less a constitutional functionary than the Chief Justice of India had recently observed that not everything that is said by a judge during the course of an interaction with a counsel in the court can be taken as revealing of the judge's views on the merits of the cause that is being adjudicated." Now, the division bench has set aside the order of the single bench and held that the time taken for acquiring a PhD degree period spent by a faculty member under the faculty development program could not be excluded while considering the period of teaching experience. That's all we have for you in this video. If you found this video informative, please leave a like and tell us in the comments how we can shape our content to bring you your legal news in more engaging ways. If you want to know more about this case, please visit our website at www.livelaw.in. We will also leave a link down in the description to the full order and the report. Don't forget to subscribe to our channel and hit the bell icon for notifications. Thank you.